arose. So what do? We were left with, okay, send the entire, only the class of the 2021-22 set, and leave the others.
How can you leave?
No, I'm just trying to explain. I'm trying to explain
where the problem started.
Yes. So we said no, we can't, because if you say, okay, send the students for 2024, you can't go and send 2023. So, but we felt, no, I mean, it wasn't their fault that they didn't go at that time. It was because of the strike. And we said, look, in order just to maintain this, fairness, we said, okay, let's give 2/3 of that 220 quota to that first set who didn't go not because they were at fault, and give 1/3 to those who said, yes. And the second set, based on extant, that's the extant faculty policy we're talking about, the parents of the students in that class were also entitled to raise eyebrows and say, this is the set of this is the turnover of our children and wards. Yes. They could make that case. And before the whole, a very genuine case. But the faculty board meeting met, it's not the dean's decision. She couldn't have taken that decision alone. The faculty board met and said, look, let us, based on her proposal, 2/3, 1/3, let us adopt it for fairness. And that was exactly what happened. Now, if the law school this time around comes up and says, okay, we're giving you opportunity, let's have your backlog. How many people do you have, both from 2020, 21, and 21, 22, 66? We now say, okay, we have about 250 or 207. They will say, okay, just front-load all of them, and they admit all of them. Now, but if the law school says, okay, we're giving you only 100 spaces, we will have to employ the same criteria so that nobody will accuse. That was why her own daughter did not come in. That was why her own daughter did not come in. I mean, if, for instance, she had, as dean, insisted that her daughter would go in, perhaps heavens would not fall. But,
Thank me for emphasis, because I was just wondering whether this allegation of the fact that ABUJA was already one of those that was favored, and I was just made to understand that she's not. That is to show that, anyway.
Yeah. Now, the whole scenario is not logical to me. The board, faculty board, that would meet and say the old students 2/3, the new student 1/3. I would have thought opportunity law school, we exhaust the first set that were denied first to the last number. Then if there is space, we add any one in the subsequent set. Because seniority is seriously distorted here. With that formula, with that idea, with that logic. So it's standing logic on its head. If I were UNN, I would say all the students, there's opportunity now to go to law school. I will exhaust those who graduated earlier, all of them, before I touch a single one from this new set to add on if there's space. Then the space will continue to be opening with that. There will be another new set 2022, 2023. They will have to wait for me to finish 2021, 2022 that I left earlier. But where some number in the 2020, 2021 will be left, and subsequent 2022 will go at 1/3, displacing a certain number because they have not been exhausted. They will become automatically the senior of those guys. Meanwhile, they graduated earlier than them. And you know, in law, there is seniority, just like in army and all that. There is zero seniority.
The allegation of favoritism, corruption may not even be genuine. It may be because of anxiety. I graduated 3 years, and because I made a 2-2, then somebody who graduated after me with a 2-1, you just favor him. You say you allocate this with 1/10 to 10. Please, man. If I'm a parent, I'll be worried. Even some parents will not want to talk about whether somebody made first class or not. What they know is that their children or their wards finish before this one that you are recommending. They were accused of favoring a particular set. So I go with the position of my colleague that if we are to solve this problem, so that nobody accuses you in future, let recommendation to the law school be on the basis of year of graduation. Until you are able to exhaust what is left behind, you should not be able to superimpose a younger person to become a senior, someone who has finished earlier. It's unfair. What we call fairness is unfair. Every fellow will crumble.
Can I, if I explain something further, sorry, sir.
Yes.
You see, that is one way of looking at it. There's another way of looking at it. That's exactly
I
why.
heard you exactly when you say the Nigerian law school requested for a particular year of graduates. And I'm telling you that if you had a window to accommodate the previous set, you should have expanded that window. You say, look, there is a pending set. You understand? Let's deal with this. Look, you are talking about people that have spent years in the university. They want to go to law school and become lawyers. You push them down and they start looking for a formula. Morally speaking. It doesn't sit well.
You see, for instance, let us say, assuming that set, this problem didn't arise at all.
Yeah.
Now, but there are years we will have, let us say, our quota is 220, but we have 270 graduated students.
Yes.
Now we only send 220. Do you understand?
Yes.
220 left. How many do we have left?
50
students.
Yeah.
Good. In the next set, it is not their priority. That is why I say extant faculty. It is not their priority because they have graduated.
But you should see that priority. That priority is wrong.
That has no, for instance,
Prof, this has become an institutional problem. It's no longer the dean's discretion that she's using here. What can we do as a Senate committee to solve this problem? Since it's beyond you, what can we do?
That is what the faculty needs, your intervention.
Yes.
And that intervention is, it's two problems. One is to also plead with the law school to increase the quotas of the faculty. If we have, I must confess, there was a time we had a quota of 310. We never met it. We never met that quota at all. So if they increase our quota from 220 to even at least 280, and another thing is,
what if the alternative is reduce the number of
Yes.
No, I didn't get that.
The question in my mind is this: if you know that your quota is 220 to Nigerian law schools every year, why do you admit 270 again? Why?
Okay.
We know you are under pressure. We are also in the same.
Along the line, some fall by the wayside.
Exactly.
Along the
How
way,
many people fall by the wayside?
along the way, they
Yeah,
fall by the wayside.
How many? I mean, it's not 100. 100 will not fall by the
Over.
wayside.
Nobody said,
fall by the wayside.
every of them fall.
You see,
Either they have missing
So meaning you admit more than 500?
No.
for one set.
Yes.
No.
Okay, what is the average?
We are talking
What
about
average?
250-ish.
That's what I'm saying. If it's 250 that you admit, and law school says bring 220, right?
Yes.
Right?
Yes.
If we bring 220,
And you are aware
if
that
we bring
backlog.
only admit 220,
Uh,
you will discover that by the time they get into the final year, not even by the time they get into the final year, the eligible students may not be up to 150.
Well, how come? How?
No. Either some have either transferred, some have either failed, some have, no.
But it's true.
No, I'm not even talking
So
about.
it means there's no problem. It means you always have a lacuna. You always have a space to fill up.
100.
That's what we are saying.
Up
If you admit 220, if you admit 250, and 100 falls by the wayside, it means you never meet up your quotas. And therefore, we are able to
We are just making a kind of a statement.
That's what I'm saying. I want it to make sense. You know why? I've worked in Nigerian law school here, not fewer than 2-3 times, to try to intervene on behalf of my constituents. I won't mention the universities. And the dean, the director then told me that the problem that they have is that you overgraduate students. You admit students, especially the private schools, because of the revenue from it. And so they graduate 500, 600, and their quota is only 200 or 400. And so every year there's always a backlog.
With profound respect, we've never graduated beyond our quota.
But then if you don't, then this is a problem for me. If you don't, then why are we having this problem? I know there was a strike, and that's what caused the backlog. If the strike were not there, would you have had all your students gone in?
Almost all of them, yes. Almost all of them, because you know, at times also some students elect not to vote.
All right, I asked you before. I said, where's the way forward? How do we solve this problem?
I said that law school is going to run a second stream.
Are you sure?
I am sure. I was reliably informed.
So if it's going to run the second stream,
Even though if you in the net you find something that thing is fake. You know something. I don't know whether you saw it. There's something on the net about it, but it's fake. I'm sure they would have collected money from these students.
How would you then accommodate these orders?
Yes, once law school gives us the go ahead to send names, we will send their names.
How many are they remaining now? Those that are complaining, how many are they?
They didn't write their names, so they just wrote 4 names here. But now what we are doing is we have asked the registry department to get us all the names of those who have graduated, those 2 sets. And
are they up to 200? Those that are remaining?
For both?
For both, they will be up to,
yes.
For both, they will be up to 200.
So does it mean that you have to continue this?
No, this formula is crisis.
Continue on this formula?
If there is
chaotic.
In fact, in the last 10-15 years, we've not had this problem.
No.
You should do something.
So,
that's why you have to be 50-50. That's what they do, should reduce the more of each. So that they can also accommodate from here.
All right, so I personally, this is not for me. This committee wants a commitment from me. This committee wants a commitment from the faculty.
Sir, what sort of commitment, sir?
To accommodate these other cells. When the law school now gives you go ahead to admit.
Why would we accommodate them? We want every look. I was even telling them.
Dean, you are a lawyer and a lawyer, you know what I'm talking about?
Yes, sir.
I want a commitment, or this committee wants a commitment from you. I don't want to talk all over the place over this. I just want a direct commitment to this committee, whether or not you will accommodate them, because you are looking for a way to solve this problem.
Yes, sir.
I've listened to you carefully, and I know your dilemma. It is quite a dilemma.
Yes, sir.
Either way you go, parents will complain. Whether you take them all, you don't take them all, you take half. There will be parents will complain, no doubt about it. But how do we solve it? And since we have started this quota, and there is the possibility that the law school is going to ask you to send names again, this is the commitment I'm asking, what the committee is asking, because they have complained. And we want to really address the issue on their behalf. Why not stressing you as well? So please, can you tell us how well you can do to accommodate this other side?
Well, I believe, or rather I'm hoping that the Nigerian law school will not ask us to bring anything less than our normal quota. That's what I'm hoping for. And if they do that, they should have come. That group, these people who are petitioners, I'm sure they are not even up to 100 because we sent 147. We entered their 2-2. So once law school gives us at least up to that 220, the remaining will go, then the other set will also go. And that's it.
You want to say something?
Yes, sir.
But don't come back.
No, I'm not going back. Well, we are just making an appeal.
Yeah, that's what we just did on your behalf.
So,
That's okay. No, sir. Don't make that appeal on just on your behalf.
So what I'm saying is that
that's okay. No.
there is no problem here, because she said that she doesn't know that one number.
No, I said don't go back. We're not, those are semantics. We're not interested in that. It's just that she did it. They are also making an appeal. Yes, actually, yeah, they are also making an appeal. And we're also making that same appeal. So we appeal to you, please, that when that stream comes on board, so please admit everyone. Is that fair enough?
Of course,
It is.
as she has
It
explained.
is.
Of course.
Well, I am hoping that law school will give us a substantial number.
What's substantial? Your normal quota, right?
Yes.
Okay.
If we
I don't
get
see why
up to
they
our quota,
I don't see why they don't give it.
we are.
But the thing is, Chairman said, you see, as soon as the law school says, okay, send 50 students, for instance. Now, even if we allot that 50 students to that particular set, it will still not take care of them. And how do you arrive at the 50%? You still have to do it in other way.
I think what you do is try as much as possible to be transparent. Let everybody knows what you're doing.
Exactly. That's it.
All right. Thank you very much for coming. We are quite impressed with your submissions on both sides.
Sir.
Absolutely.
Sir, you didn't say anything about what they did to me. Thank you, sir.
We are happy that, first of all, you've come this second appearance, third appearance,
We need to have been 3 times.
and that shows to us that you are very respectful of the system and what we are doing here. And so we say thank you for taking time out to come. We know how busy it will be in the faculty. Sir, we're trying to come to a fair decision here that also will be presented to you and those you represent. On the issue of what you consider the maligning of your name and person, I'm going to apologize on their behalf. Please take it from us. It's sometimes issues like this come up and you speak before you think, or you listen to some allegations that you haven't actually gone into seeing how credible it is. Because it's based on what your client or what your constituent tells you. But in any case, it doesn't meant to really hurt you the way it did. And so I, the chairman of this committee, apologize on behalf of that letter, of the person who done it. Just take it from us and let us not go beyond this. Is that acceptable?
I can also accept on your behalf.
Who will accept on my behalf? Not you, sir. Sir, what do I do? Do I have a choice? But my joy and happiness is that we have lawyers on that side. And you understand the enormity of what is but well accepted.
Thank you. I appreciate it. Thank you so very much. So on behalf of this committee, we thank you for coming and sir, communicate to you. graciously, the Dean will do everything to accommodate them once the possibility comes up. Alright, but if there's anything, come back to us, Senators. So this case is adjourned.
Thank you. Thank you, sirs.
Good afternoon, everyone. The chairman and all the members of this committee.
Are they taking the vote?
I'm coming to that.
No, you start.
I want to do this before taking the
Take
vote.
That's
I, Mike Esquire, do solemnly affirm that the evidence I shall give before this distinguished committee shall be the truth, the whole truth, and nothing but the truth. So help me God. Like I said, my name is Mike Esquire, the legal practitioner representing FLAUBERT in this matter. Thank you.
The chairman of the committee, my name is Senator Onyeka Peter Nwebonyi. I represent the South Senatorial District.
Thank you, Mr. Chairman, our guest. My name is Senator Abiru M. I represent the Ebonyi North Senatorial District and Deputy Chairman of this committee.
Thank you, Chairman and Vice Chair. Invited guest. My name is Senator Anthony Siakoyaro, representing the South, a member of this committee.
Having introduced ourselves here, the petitioner, Esquire, you represent Mr. EWATO? Is that Mr. EWATO?
Yes, sir.
And he represents you?
Yes, sir.
You please tell this committee what you want to say.
Yes, the first day we were privileged to be here. We presented our case, and we made it clear to this committee that Mr. FLAUBERT, just beside me here, who petitioned this committee, was dismissed, arrested, and summarily tried and dismissed from the Nigerian Navy for an offense that is not known to law. He was accused of illegal mounting of roadblock. And that offense is not known to law. Section 36, subsection 12 of the 1999 Constitution expressly states that every offense being accused of must be known to law. And this position is best explained in Latin maxim, nullum crimen sem lege. That means that even if that offense is expressly stated, an offense is not, the offense of it is not stated. The punishment of it is not stated. It's not an offense. He was apprehended for illegal mounting of roadblock. And an illegal mounting of roadblock, the intent is for extortion. But extortion, the offense of extortion is expressly stated in section 108 of the Armed Forces Act. And the ingredients of that offense is that, and to be successful to prosecute somebody for offense of extortion, first, the victim of the extortion must make a confessional statement that he is the victim of offense of extortion. And the person accused must be found with that which is extorted from that victim, either cash or any other item being extorted. But in the instant case, Mr. FLAUBERT was just found with biscuit and mineral that he bought. And after that, he saw the military officer coming. He saw them, he went to them to greet them. Immediately he was apprehended. He asked them, what is the problem? He said, it's an intelligent report that he mounted illegal roadblock. And again, we said that if somebody even if there's any intelligent report, but the scene where you found the person, did you find him with anything? No weapon standing. Because if we are extorting money from, there must be something to intimidate the person we are extorting money from. And he was not found with anything. That case is over. Now, when I said that, okay, it is a well-established principle of law, and indeed the rule of evidence. Cited section 135, subsection 2 and 3 of the Evidence Act, 2011 amendment, that the burden of proof is always on the one who alleges. Now, when we establish that the committee on the day we presented our matter, asked the lady presenting, then okay, let them present the document, the procedure, because it's not just evidence, it's evidence credible enough to establish a prima facie case. Now, they were present on that day, but they said there was no evidence they could present. So now, the body to prove whether this man was extorting money from people is on them now to establish. The procedure that lead to the dismissal have not been presented, have not been adduced before this committee. So it is their duty at the moment to tell us what they have, the offense they have committed, and this is what they have. They have laid hands on against it. That is the situation, and that is our submission. Thank you, sir.
Thank you. Thank you very much. I know that as a counsel, of course, you'll be very passionate in presenting your client. I understand that very well. This case is not a new one. I think I can recall very vividly the first time we had this case here. But we also asked some questions, and we thought that those questions, once we get the answers today, perhaps it will lead us to the direction of this case. And one of those things is that we asked that the Nigerian Navy to submit the proceedings to the court-martial against Mr. EWATO, whether in the course of detention and dismissal of the petitioner's salary were paid to him. These are two things we requested: court-martial, one, the reports of that court-martial, and two, whether or not in the course of all of this, his salaries were paid to him. Those are the two questions that we want to have an answer to. So let me give the opportunity to the Navy officers to address us on this.
The chairman of this distinguished committee, the vice chair, distinguished members of the committee, ladies and gentlemen, I am Rear Admiral Daniel Ataba, the Director Manning Naval Headquarters, and it's important that I state that I just assumed this office barely 2 weeks ago. And so I have with me here the Navy legal expert who is very vast with this case, who is abreast with this case, to answer some questions. So I'll take the indulgence of Mr. Chairman to simply read out the Navy's position on this, the response, and thereafter have the floor to field questions which I will answer in conjunction with my legal experts with me. If that is granted, I proceed.
Go ahead.
All right. I am today appearing in respect of the petition by ex-seaman EWATO, FO
X15028, who alleged that he was wrongfully dismissed from the Nigerian Navy. The petitioner was serving on board Nigerian Navy ship Lugard at the time of the alleged wrongful dismissal. He averred that at about 0330 on 26 August 2021, after he was relieved from his duty, he went to Magajia community, and on his way back, he was arrested by a team of Nigerian Navy personnel. He stated that he was kept in close custody till 26 January 2022. The petitioner further stated that he was summarily tried by the then Commander Nigerian Navy Ship Lugard, Commodore C.E. Atebi, though now a rear admiral, on 2 counts of absence from duty and mounting illegal checkpoints. Particularly, the petitioner claimed that he was awarded 28 days imprisonment with hard labor on the first count and dismissal from service on the second count. He contended that he was not given fair hearing during the trial and there was no evidence to convict him on the second count. The petitioner equally averred that his dismissal from the service was only confirmed 6 months after the sentence was passed. He also claimed that prior to his dismissal, he did not receive salary for 1 year. The petitioner further claimed that having been locked under close custody, he was denied the opportunity to seek a review of the sentence within 1 month as required by the Armed Forces Act. To this end, the petitioner is requesting a review of his case and for the sentences to be quashed, payment of outstanding salaries and allowances, as well as reinstatement to the service. It is based on these allegations that the committee is requesting a response from the Navy, to which I will provide. Available records, as disclosed by the report of summary trial, indicates that while the X-rating was on temporary duties at Nigerian Navy School of Artillery of Armament Technology, Kachia, from Nigerian Navy ship Lugard, he was absent without official leave for a period of 1 year and 27 days. From 1st June 2020 to 27 June 2021, upon his return to Nigerian Navy ship Lugard, his mother unit, from whence he proceeded for that temporary duty, he was summarily tried for the offense of award, absent without official leave, convicted and awarded reduction in rank from seaman to ordinary seaman, that is 1-step reduction in rank, with effect from 12th August 2021. However, while awaiting confirmation of the sentence, the rating was deployed for duties at the main gate of Nigerian Navy ship Lugard Observation Post on 26th August 2021. The X-rating subsequently abandoned its duty post on the same day, 26th August 2021, and boarded a J5 bus to Magajia village, about 5 kilometers from the base, and mounted an illegal roadblock with the intent to extort money from motorists. Following the receipt of intelligence report on his activities, a team was dispatched from the base, and upon the arrival at the scene, the X-rating was seen dressed in complete camouflage and a ballistic vest, in company of 2 civilians at a section of the Abuja road, where tires and logs of wood were used as roadblocks. It was also revealed that the X-rating extorted money from motorists, claiming he was providing security for the trucks parked by the roadside. The X-rating was thus arrested and brought back to the base on 26 August 2021. Consequently, the X-rating was summarily tried by the Commander Nigerian Navy ship Lugard on 2 counts charges of conduct to the prejudice of service discipline and offense in relation to sentry duties contrary to sections 103 subsection 1 and 50 subsection 1E of the Armed Forces Act, respectively. It is instructive to note at this point that the X-rating appeared for the officer of the day's table. That is the naval summary trial of first instance. It kickstarts the whole trial process in the Nigerian Navy.
on 20th September 2021, where he pleaded guilty to the charges. He pleaded guilty to the charges. He also pleaded guilty to the 2 counts at the executive officer's table, that is the second level trial stage, on 6th October 2021, following which the case was referred to the captain's table, the 3rd and final summary trial stage. At the captain's table held on Tuesday, 24th January 2022, the charges were read to the ex-rating, and he confirmed that he understood the charges and thereafter pleaded guilty to the 2-count charges. The ex-rating specifically blamed his actions on the devil at that instance and begged for forgiveness at the captain's table. Notwithstanding the foregoing, the prosecution presented the evidence, including pictures of the ex-rating in complete camouflage and ballistic vest at the point of arrest, taken by the team that effected his arrest. Consequently, is that an interjection? Okay. Consequently, the ex-rating was awarded dismissal from service on count 1 and 28 days imprisonment with hard labor on count 2, arising from the foregoing. It is evident that the petitioner's claim of lack of fair hearing cannot be substantiated. It is expedient at this point to inform the Senate Committee on Ethics Privileges, this committee, that the summary trial proceedings of the ex-rating conformed with the procedures spelled out in extant regulations of the Armed Forces of Nigeria on summary trials. Therefore, the officer was right in awarding dismissal, which is within his powers of punishment under Section 116 of the Armed Forces Act. In the Supreme Court case of Mohammed versus the Federal Republic of Nigeria, the court held that, quote, having pleaded guilty to the charges and the learned trial judge having satisfied himself that he understood what he was pleading to, the next stage of the proceedings was conviction and sentence, unquote. On the ex-rating's allegation that he was precluded from appealing for a review of his sentence within 1 month due to his incarceration, it is pertinent to point out that the trial process was only complete upon confirmation. In this instance, the confirmation was dated 16th June 2022, whereas the effective date of the punishment was 25th January 2022. According to the ex-rating's claim, he was released from close custody on 25th January 2022. Hence, he had ample time and opportunity to appeal for a review of his sentence. It is equally important to mention that the basis for the ex-rating's incarceration was his tendency to escape. As stated above, the ex-rating's antecedents showed clearly his propensity for this absconding, as he had earlier been on a wound for a period of 1 year and 27 days whilst on temporary duties at the Nigerian Navy School of Armament Technology, Kachia in Kaduna. Thus, it is respectfully submitted that the trial was properly conducted in accordance with extant regulations. On the issue of the ex-rating's claims of non-payment of salary and allowance, investigation disclosed that the ex-rating was on a roll from 1st June 2020 to 27 June 2021, 1 year and 27 days, whilst on temporary duties at the Nigerian Navy School of Armament Technology, Kachia. Subsequently, the ex-rating was marked wrong and declared a deserter. Consequently, his pay was stopped whilst on a roll. On his return, however, to Nigerian Navy Ship Lugard on 28 June 2021, the ex-rating was tried summarily by the Commander, Nigerian Navy Ship Lugard, and awarded reduction in rate from seaman to ordinary seaman, worth 12 August 2021. By the provision of Section 205 of the Armed Forces Act, the ex-rating is not entitled to pay from 1st June 2020 to 27 June 2021, being the period of his award absent from work. Nevertheless, it is admitted that the ex-rating is entitled to payment of salary from the date he returned back from the award. Accordingly, this committee is requested to note that the Nigerian Navy will dictates the payment of salary and emoluments due the ex-rating from the date he returned back to the Nigerian Navy from his award. From the submissions above, it is apparent that EWATO, FLAUBERT, OLUWADOLAPO's dismissal from the Nigerian Navy is a direct consequence of his actions. I am to state that his continued indiscipline and lawlessness negated the good order and discipline of the Nigerian Navy. Therefore, his dismissal was necessary to maintain service discipline and integrity. It is therefore humbly submitted that the trial was properly conducted in accordance with extant regulations. The Nigerian Navy is a law-abiding institution, and if the ex-rating was not satisfied with the judgment, he had the right of appeal, which he was at liberty to exercise, like a lot of personnel in similar circumstances have done in the past. But in his own case, he failed to do so. This brings me to the end of the Navy's position on this matter. At this point, we are available for questions, which the legal experts will also attend to. Thank you, Mr. Chairman.
Thank you very much.
Thank you. Let me start with the legal man, or the Mr. EWATO. It is true that you were absent from service for good 1 year.
No, sir.
Yeah?
No, sir.
So you are now saying that you never tried for that.
Sir, why are we here?
No, not what you are here. It is also part of yes, no. Was there any time because of your service?
Sir, request, sir. I will request to distribute the dismissal letter to you. The dismissal letter does not have the offense, the formal offense. The formal offense which I was tried.
Were you trying for that?
At any time.
You absconded for
award
for 1 year,
27 days.
No, sir.
So what they are saying is not correct. There was no time you left service. Is that correct?
Yes, sir, correct, sir.
No, you have to be sincere to yourself because you are here seeking for justice. And if you want to get justice, you have to defend yourself. Just tell us the correct position. You were on a wall for 1 year, 7 days.
Counsel, please talk to your client. Talk to your client.
It's not just an answer, it's just a direct answer, yes or no.
For me to be here by no word. But it's not by my power, it's not by my grace I'm sitting here. But to be sincere with myself, since my dismissal in the Nigerian Navy, I have not been myself because my joy has been taken away from me. And what made me go to the Senate was concerning my dismissal, which I knew I did not commit that offense.
Counsel,
That's not answering.
Counsel, you have to get your
7 days.
Let me,
it's as simple as ABC.
let me
Trying
try
to get you.
Let me ask you. What he's trying to say in essence is that we have never been involved in anything wrong in the service before, and he have never been tried or accused of being absent from duty since he has been in the Nigerian Navy. The only offense is what he's facing today, and it's the offense of illegal mounting of law, but when you have made it clear that that offense is not an offense known to law, and it's clear there is no this. We have Armed Forces Act, and all offenses are contained. If they can show us where.
Counsel, you are not making a submission here before us. We are not asking for legal arguments. We are trying to understand the subject matter as it is. So that is the why they brought some issues which we are now trying to clarify. One of the issues they raised was that yes, there was a time he was on award for 1 year, 27 days. And when he came back, they accepted him, but the only thing they did was that they grab him and then allow him to continue, even though they have not paid his salary for the period he served before his dismissal. So what I tried to find out, is it correct? Yes, there was that incident.
It's what he's telling me here. It's what he's telling me that I thought they were involved in anything wrong. But it's that's what he's telling me.
What rank was he?
I was dismissed as a seaman. The dismissal letters are with me, yes, sir. I was dismissed as a seaman in Nigeria, sir.
As seaman, not one rank below seaman.
No, sir. Seaman, sir. The dismissal is carrying seaman, sir. I request to forward all my documents, sir. The dismissal is carrying seaman, not ordinary seaman, sir.
May I copy of that?
Yes, sir. I do, sir.
No, sit down.
Sit down.
No, sir. Yes, sir.
Officer, if I may ask, what is the position, what was his rank before his dismissal?
Thank you, Mr. Vice. The rating was a seaman as at the time he committed his first offense for which he was tried, disrated to ordinary seaman. But the procedure in the service is that you must await confirmation before you execute that pronouncement, that sentence. And it was whilst awaiting that confirmation, still wearing a seaman rank, that he went into this second offense of committing mounting illegal road block. And so when he was tried for that and dismissed, that was without the confirmation for that reduction in rank. So he was still known to be a seaman because that confirmation never came. And the process of confirmation is always after a review, the Navy Board review and some other long procedure. So it was because of that, that what you have before you still reflects him as a seaman because that confirmation never came before the committal of his second offense for which he was tried and dismissed.
So you have not served him with the
reduction in rank? No, sir.
And it was not communicated to you? He has no knowledge of that?
Well, okay.
Sir, with due respect, sir, distinguished members of this committee, I am Commander J.I. Okon, Staff Officer 1, Legal Review, Naval Headquarters. The procedure is this. Once there is a trial, summary trial, the sentence will be pronounced right then. But because we want justice to be done, that report of that trial will be forwarded from wherever that trial was conducted to Naval Headquarters. And then it will be reviewed. Once it is reviewed and we see that the procedure was properly taken and everything was done properly, then the Chief of Naval Staff will confirm the sentence. Now, the Air Forces Act provides that until confirmation is gotten on any punishment, that punishment is deemed not yet, you can't go and remove its rank, yes, until that confirmation comes. So if confirmation takes 2-3 months for it to come, he will still wear his rank. So in his instant case, he was a seaman. So the record you have before you have the report of the first trial where he was absent for 1 year. Is let me count from 10. You should count 10 from the first page, sir. Yes, because there are different enclosures. But it's numbered 1, restricted, and it's dated 11th May 2022. That's the report of the summary trial procedure. So, when he was absent for that 1 year, 27 days, he was awarded reduction in rank. So, pending the confirmation, he was sent on TY duty to another place, and then he abandoned his duty post. So, with due respect, it was not just the fact that he mounted illegal roadblock that he was tried for. It was abandoning of duty post. That was the ingredient of the offense. Because he was to be at the main gate at Nigerian Navy ship ENUGU. So he abandoned that place and he was found at a different place entirely, which is 5 kilometers away from where he was supposed to be. So abandoning of duty post is an offense under the Armed Forces Act, and he was charged under section 103, which is conduct to the prejudice of service discipline. So all the reports of the first and the second trial, they are there for you to peruse.
Which says the second report is page.
So this first one is dated 11th May 2022. The second one, then you now see the signal of the dismissal. Then you see the report of the summary trial. After that signal, there's a signal dated 16th.
The signal is the one with the handwritten.
Reference B and closure 2.
After reference B and closure 2, then you have the report of the summary trial. And so just as my learned senior here said, since he was absent, there was no way they would pay you for being absent. So the period he was absent from work, for that period of 1 year, he was not paid because no work, no pay. That's what operates. But when he came back, he would have been paid his salary for that period. But because the confirmation is pending, he was not yet paid, then he committed another offense. So now, the Navy is going to pay him for that period.
What's the period? How many months or how many years?
Is from the day he came back. He came back to service on the 27th of June 2021. So they will start paying him from that day till the date he was dismissed.
How many months?
I can quickly do the rough mathematics. From June 2021 till the date of his dismissal.
What date is that dismissal?
July 16.
So about 1 year, sir.
About 1 year.
Yes, sir.
All right, quickly.
Is that the salary alluded to that you are not paid?
Yes, sir.
That salary alluded that you don't pay?
Where I was working, sir.
Hold on. The period June 27, 2021 to July 16, 2022, is that the salary you are saying that they have not paid you?
Yes, sir.
Okay, I just want to make that clear.
Yes, sir.
I've been thinking as everyone is talking. Did you ever make any statements to the Navy while you were arrested?
Sir.
Did you ever make any statements in
Any
writing?
statement?
In writing to the Navy?
Yes. Yes,
do you have the statement in front of you there?
I don't, sir. And I've written so many statements because there was a time I wrote to the chief of naval staff and they called me.
I want to read this for us. Show it to his lawyer first. Show it to his lawyer. Is that your handwriting? Is that your handwriting? Is that your handwriting?
Yeah, that's my handwriting.
Okay, read it to us. Read it to us. Turn the mic. Turn the mic. Read it. Just read it from the beginning. After.
Not read it
I
yourself.
said, read it on the hearing. Keep on the hearing.
So I'm trying to see it, sir.
Don't.
See what?
You want to read it to that?
No, I want to see it because it's not clear yet. Sorry, sir. I was on. So I want to see clearly. Sorry, sir. I was on duty at the NSUKKA main gate on Wednesday. So I was off duty around 00 hours.
I can read it out, maybe.
No.
Sorry.
This one is not clear.
Okay,
It's not clear.
it's not clear. And also, sir, I will don't give him that.
I want to get that first.
Okay.
Council.
I was on duty at the NSUKKA main gate on Wednesday. So I, on my duty, around 00 hours. So I walked to around. Sir, please, sir. I want to request, since she said she can see it, me, I cannot see it.
She may read something wrong against you now. Okay,
Sir, I'm not even asking. You asked me whether it's my handwriting.
Give your lawyer.
I saw my name. That's why I said
Give
yes.
your lawyer. Off your mind. Off your mind.
Sir, I can't afford to read this.
Okay.
It's not legible enough for me to.
Okay.
So if you can read it.
I can read it. I've read what is there. I just want to hear from his own mouth. That's all. See, Council,
Sir,
off your mic. This is not a law court. You can call it the People's Forum. I mean, that's the process I can call it. We try to help citizens who cannot confront the authorities, especially those who feel that they have been unfairly treated. We don't also do that by undermining the system itself. There has to be a balance. And when you come here, the reason why we say take the oath is because we expect you to tell us the truth, the whole truth, and nothing but the truth. If you don't assist us with the truth, I don't see how we can assist you with the solution. Council, we are up on it. You can agree with me that we have good clients, we have bad clients. This is a bad client. He can read what we ask him to read, but he doesn't want to read it. And he doesn't want to read because he's self-indicted. And we don't want to go that route. The route we want to go here is to see how we can help him. That's the route we want to go. And so by trying to avoid and evade questions, it doesn't help me personally. And I'm sure it doesn't help my colleagues sitting here. Because we would have been someone else doing something else. We have so many committees going on. There are so many things that we need to take care of on behalf of the larger nation. So to have him sit here and not tell us simple questions that we ask him is not, it frustrates me, and I'm sure it frustrates my colleagues as well. The question of AWOL is trying to tell us that that's not why he's here. Therefore, we shouldn't even about our minds to it. And we're talking about the issue of character. And you know that character goes straight to the issue of why we're even here. But again, we don't want to delve into that one at all because it's going to take so much of our time and it doesn't help us to come to a solution. We want to help him. That's the whole thing. That's the whole point. I'm happy that the Navy have said here before us. And that's the commitment we're going to take, actually hold them to. That for the period of June, for the period of 1 year, June 21, June 20 to July.
The period of August 2021, 6th August 2021 to July 2022.
The Nova Council. Please step up with that figure. I want to know exactly the period to what period.
It came back.
I wrote it down somewhere. Where's my Bring it. You see my main notations on my I made notations on my notes. Bring it. So I have written here June 27, 2021 to July 16, 2022. That was the figure that was given to us. Let us agree on that period so that we can make some progress here.
So he came back 27 June 2021.
Okay.
So his salary will be from July 2021 to June 2022 because his dismissal was
July 2021
to June 2022.
to June 2022. That's the salary will be,
Yes,
right?
sir. Yes,
Okay. Now, this is a commitment that this committee.
So what will be his position within this period? Because I was meant to understand that the motion was not communicated to him up to the time of dismissal. Am I correct?
Yes, sir.
So what will be his position? Supposing now, what will be his rank now?
Okay, sir. When we get back to the office, I'll check if there was a confirmation after. Because the record says while confirmation was pending, he was dismissed. So if there was no confirmation, that means he will still be on SEMA.
That is
He will
to
still be on SEMA. But if there is a confirmation of that other sentence, he will be given the salary of.
Well, we have just said it now. That they have said while his confirmation, while waiting his confirmation, he was dismissed. So that there was no confirmation.
No, that the dismissal will be confirmed it will not be confirmed until the boss confirms it, right?
Yes, sir.
Okay, that's what you want to check, whether or not it has been confirmed.
Yes.
Okay, because it's gone through the trial.
Yes.
Now it needs to be confirmed.
Exactly.
Okay, that's the Supreme Court. That's the Supreme Court. Okay. So it's the Supreme Court of the Navy concerns the land. Okay. So at that point, we'll know whether or not it's going to be the seaman rank or lower. Okay. But in any case,
So the assurance is he will be paid for that period he was back to.
all right, very good. Council, talk to me. Talk to me. You heard it?
Yes, I've heard
Talk
what he
to me.
says.
Talk to me.
Yes, I've heard what he says. My appeal here is that the man, Mr. FLAUBERT, should be reinstated. That is my appeal.
Should be what?
Be reinstated. Whatever bill it is, he should be pardoned for whatever thing they have done wrong in the service. Considering the economic exigency, he's struggling with his family, the children cannot pay. And if you allow him to go again to the society, I wouldn't want a situation where he will go and join the bad guy. He's facing a lot of challenges. We should look at him, and he will never for any reason get involved in anything wrong in the service. He will never try that again. So my appeal to this committee is to make recommendations that he should be restricted, whatever be the case. He should be forgiven for the sins he has committed in the service. That is just my humble appeal.
All right, Council, thank you very much. I'm sure they also heard you. But my problem is that he has not come to this committee. He hasn't come to us. But we'll help you. We'll also appeal to them and see. But see, they have a procedure. We have a procedure, and we cannot interfere with that procedure so long as that procedure is fair. So long as that procedure, the procedure they have is fair, it is not targeted against him for any reason. That's the procedure they follow. It doesn't matter who falls within it, and that's where it falls. If that's the case, then that discretion is going to be left with them. But one thing I can assure you is that they have given us a commitment that the salary will be paid, and we hope and believe that they should stand by that. All right. All right. Thank you, gentlemen. Thank you very much for coming. Sir Johnson. All right, gentlemen, thank you for coming and for being so patient with us. As you can see, it's past 5 o'clock. This is how we work. This is how we work in the Senate. Even though some people think we don't work at all. Anyway, the case before us is not going to go anywhere because we have a letter from the petitioner's attorney stating that that they have gone to court in respect of this same matter. And if they have gone to court, then we completely hands off the procedure. So we will not even bother to waste any of your time. And on the basis of the fact that this case is in court, we hands off jurisdiction, and so this case is dismissed here. Thank you so very much. Thank you very much. Nice.
This one.
versus Nigerian Council for Arts and Culture, NCAC. Both parties have requested that the case be adjourned for them, and the committee have graciously done so. This case adjourned to 13th of March 2024. The second is DK Rigange Esquire of EM Shana and come on behalf of Mr. Chabiya Ben versus Nigerian Agricultural Land Development Authority. Also graciously requested for us to adjourn this, and so we adjourn to the same date, which is the 13th of March 2024. Thank you. Having exhausted today's activities, we hereby adjourn this sitting until the next sitting day. What is the next sitting day? Which is the 13th of March 2024.
Sorry, sir. I came with respect to the case in the news case.
Oh,
yes.
Actually,
the case has been adjourned, but I shouldn't be seated here while the case is adjourned, at least. That's why I requested.
When?
The one that is Shabia's case. The second one adjourned.
Who do you represent?
Shabia.
Okay, you represent the petitioner.
And the second case
Okay, you present Shabia.
Shabia, yeah.
Okay. Are you an attorney?
Shagna.
Are you a lawyer?
Yes, sir.
A lawyer. Okay. Let's not put it on the table.
I declare that the Esquire do solemnly affirm that the evidence shall be before this solution of this shall be the working and function of the instruction.
Thank you very much. Like rightly said, I think we had a notice from the respondents and that they won't be able to make it here and requesting for an adjournment. I'm not sure you were told about that. So I apologize on behalf of the committee. I didn't know we were on this case. I thought actually we were with the other cases for not letting you know, so that you wouldn't have sat here all through the course of this proceeding so far. But we're here now. And let me give you two options. If you want to tell us your case, we'll be willing to hear you. But if you want to wait on the adjourned date, because this is the first mentioning of the case, and so we'll likely accept grant adjournments when requested. As it's been requested and granted it. But if you want to wait and come back on the adjourned date so that you can give summary of your case in the presence of your respondent, that is also good. So I give it a choice. Do you want us to hear you and hear you again, or do you want to come on the adjourned date so that we can hear everything together?
My name is Nambabakir Lady, from PM Shagna, who represent the petitioner, Mr. Shabia Benham. Mr. Chairman, the Honorable Committee, is my singular honor to appear for the petitioner and apologize for his absence. We would have loved to have a bite based on the options given to us, but that bite will still be repeated now that there's an adjournment letter. All that will be done here will be in Indonesia, even though we will repeat it. Because our case is just an issue of unlawful dismissal. And we appreciate at the next adjournment we make our presentation while they're here.
Thank you very much. So based on this agreement and understanding, this matter is adjourned to the 13th of March 2023 for both sides to be heard. And so this case is adjourned and the committee stands adjourned as well.